Good afternoon, everyone. My name is Nichelle Dinoon, Librarian 3, Tobago Library Services. Tobago Library Services is pleased to be collaborating with Tobago Writers Guild to host conversations on copyright. As the world at large celebrated World Book and Copyright Day on April 23rd and prepares to celebrate World Intellectual Property Day tomorrow, April 26th. Presenting this afternoon are two attorneys at law attached to the Intellectual Property Office, Office of the Attorney General and Ministry of Legal Affairs in Trinidad. Also present is Mr. Kavish Sitahal, Deputy Controller of the Intellectual Property Office. We thank you for accepting the invitation to present and look forward to the wealth of knowledge you will bring to us this afternoon. Tobago Library Services and Tobago Writers Guild are two different entities, however, our clientele is inextricably linked. Tobago Library Services serve a clientele that is mainly consumers of copyrighted work. They use these original works for leisure and educational development, while the Tobago Writers Guild mainly serve writers, those who are the creators or producers of copyrighted works. As such, this evening's presentation is somewhat twofold, as it will treat with matters relevant to producers and consumers of original works. We hope that at the end of the presentation, those of you who write will be motivated to continue producing, knowing that your rights are protected and you'll be assured full benefits, economic and otherwise, from your work. We also hope that society will continue to benefit from the work you produce. In terms of those of you who use information, we hope that you will use it responsibly or in a responsible manner so as not to infringe on the ability of owners of copyrighted work to benefit from their hard work, bearing in mind that copyright infringement is a criminal offense. I thank you for your attention and do hope you enjoy the presentation. At this time, I hand you over to Mrs. Joelle Green-George, who will introduce our speakers before they begin their presentations.
Good evening, everyone. Thank you for being here.
Good afternoon.
I will be introducing the presenters and be giving you a brief, peek into their careers and into their professional lives. We have with us today Ms. Anelia Baiju and Ms. Lorinda Passat. Ms. Anelia Baiju has over 10 years working experience with the Intellectual Property Office of the Attorney General and Ministry of Legal Affairs, and she is a senior trademark examiner of the Madrid Protocol Processing Unit of Trinidad and Tobago. She has a Bachelor of Science in International Relations from the University of the West Indies and a Bachelor of Laws degree from the University of London. Ms. Baiju has also completed many advanced World Intellectual Property Organization courses in the areas of trademarks, industrial designs, geographical indications, copyright, and IP management, just to name a few. Ms. Lorinda Passat is attached to the Intellectual Property Office of Trinidad and Tobago as the Legal Officer 2 for over 4 years. She has a Bachelor of Laws and a Legal Education Certificate from the Hugh Wooding Law School. She is also the holder of a Master's of Business Administration in Leadership, Entrepreneurship, and Innovation from Anglia Ruskin University. Thank you very much for being with us today.
Thank you so much, Mrs. George, for the warm introduction. So just to correct the record, I am not an attorney. The two attorneys are Ms. Passat and Mr. Sitahal, right? So we want to have the session very engaging. I mean, it's 5 in the evening, right? So any questions that you have, please post them in the chat and they will be addressed accordingly. So allow me to share my presentation now. All right, so let me know if you see my screen. Yeah, okay,
yes,
good. Right, so today we are commemorating World Book and Copyright Day, which was celebrated April 23rd, and also we are celebrating World IP week, I should say. Yes, we celebrate April 26th is World IP Day, but we also celebrated the entire week. We actually started our initiatives along this line since last week Friday, to be correct. So today we are focusing on copyright, and this presentation will be delivered by my colleague and myself. And while the focus will be copyright, we will want to basically set a foundation, touching what is intellectual property, look at some of the various types of IP. Then we go into the major focus being copyright, neighboring rights, the term of protection, ownership, exceptions, infringement, and so on. So firstly, what is intellectual property? And it refers to the express creation of the human mind. So this is defined by World Intellectual Property Organization, which is a specialized agency of the United Nations. So notice it says expressed, so it cannot be something that is still in your head. It has to be fixed into a tangible form. You have to sing it, you have to dance it, you have to write it in order for it to be afforded some sort of protection. Now, can anyone tell me who this guy is? If he looks familiar at all? I mean, you can open your mics and let me know if you know anything about him. He has a beautiful smile. Or perhaps you can post it in the chat. I can't see the chat right now, but my colleagues can tell me. Anything?
No.
No suggestions yet in the chat.
Nothing so far.
Okay, I'll give you a hint. His name is Naruto. Anything?
No.
Okay, all right.
I don't think they're
Okay,
familiar, but they will be.
This guy, so his name is Naruto, and he took a selfie. Now, when someone takes a selfie, they usually own the copyright in the picture, right? So if I say this and I say, okay, Naruto took a selfie, you think he owns the right to that picture? Yes, no?
It's coming in hot and sweaty. It's coming in hot and sweaty.
I've seen some suggestions from Georgia. Let's see, and
Shaman,
Shaman, yeah.
If he is a monkey. Georgia's famous. This came up a few years ago.
Yes,
Georgia,
yes.
he does own the right, Georgia. All right, okay.
Okay. Thank you, Georgia. Right, so this picture actually triggered a dispute between the photographer who set up the camera. So this photographer is David Slater, a wildlife photographer, and he set up his camera, and lo and behold, you had Naruto the monkey taking the selfie, right? So the short version of this story is that it went to court, and you had a group representing Naruto. They were called the People for the Ethical Treatment of Animals. And in essence, what came out of the court is that animals have no standing in court. So therefore, as the caption says, copyright is not monkey's business. So we have the link on the slide. You can click on it. The presentation will be shared, and you can read some more about this interesting case. So moving along, IP is divided into two branches. You have copyright and neighboring rights, and you have industrial property. Now, under industrial property, you have various types. You have trademarks, which basically protects brand. You have patents for invention. You have industrial design that protects the ornamental aspect of an article, how it looks. You have geographical indications. And what should be noted about these various forms under industrial property is that it's territorial in nature, which means that if you want protection in a particular country, you need to file in that particular jurisdiction, right? As opposed to copyright and neighboring rights, where you have protection in all the countries that have signed on to the Berne Convention, which is the overarching treaty for copyright and neighboring rights, right? So here we have a listing of all the works that are protected under copyright. So the works being the creations, you have writings and dramatic works, musical works, sculptures, works of mass. So when we talk about works of mass, we're not just talking about the physical costume itself, but the entire stage production, right? We talk about computer programs are also protected under copyright. What is copyright? So copyright protects original literary and artistic works. So when we say original, it has to have some sort of skill and effort that would have been put into the creation of this work. And there are different types of literary and artistic works. So we talk about novels, we're talking about paintings, we're talking about sculptures. So these are just some examples of the different types of work that are protected under copyright. Right, so I said it has to be original, so it must be the author's own intellectual creation. And because it's the author's own intellectual creation, they have the right, and that right is to copy their work, right, or also control the copying of their work by third parties. Here we have the various legislation that governs copyright. So we have the Copyright Act, Chapter 8280, and copyright regulations, and then you have the copyright. We have Act number 14 of 2020, and this amended the Copyright Act to give effect to two important copyright treaties. You have the Marrakesh and you have the Beijing treaties. So the Marrakesh, which gave or actually facilitate access of published works to the visually impaired persons. And then you have the Beijing for performers with regard to their audiovisual performances. So we have touched in the various works that are protected under copyright. So I'm going to skip this slide, right? Next, are unpublished works protected by copyright? Yes, they are protected by copyright once they are original, literary, artistic, or dramatic works. And here we have citation from the Act itself, Section 19(3)(c), which provides that in the case of collective works, the collective work would be two or more persons, other than a work of applied art. And in the case of an audio-visual work, copyright and moral rights shall be protected for 100 years from the making of the work if the work had neither been made available to the public nor published before 25 years after. All right, so that's the citation there. If you need further clarification, we have the two attorneys that will provide further clarification on this. All right, so moving along, what can be protected? So we looked at what can be protected. Now we look at what cannot be protected. So ideas, it can't be protected unless you fix it into a tangible form. Procedures, discoveries, made data unless it has been organized in a form of a database, so that would be subject to copyright protection. Legislative texts are not protected under copyright, official translations, political speeches, so the idea is that this should be available for all to use. How does one assert your copyright? So copyright protection is automatic. There are no formal procedure for you to go about protecting your copyrights. As in the case of, if it's a trademark, you'd have to file an application with the office and you go through the procedure. So copyright protection is automatic once it's fixed into a tangible form. So the various ways of asserting your copyright are listed here. And this is basically where you're giving notice to the public that you are the creator of the work. All right, so the first way would be the use of the copyright legend. Now, this will be very familiar to all of us. When we open the book, you actually see this. You see the copyright notice, and it's actually worded like this: copyright owner, the year published, all rights reserved, and so forth. Then we have the poor man's copy. So this is basically sending a copy of the work back to yourself via registered mail. All right, so in the event that someone is infringing on your work, you can submit it to the judge as evidence. And then you have a statutory declaration. So you go to JP or Commissioner of Affidavits, and you would swear this document, which will say that you are the creator of the work, and you attach a copy of the work to that statutory declaration. Now, having said that, what is the purpose of registering copyrights? So you see, it's linked to what I would have said before, right? So in Trinidad and Tobago, registration is not required under the Copyright Act to obtain protection because we said it's automatic, right? So it's automatic, no formal procedures is required as a precondition for obtaining copyright protection, but we must ensure that we attach the copyright notice and we go about these various ways in terms of asserting our copyrights. What is the term of protection? The general rule is life of the author plus 50 years after he has passed on. With regard to collective work, it is a period of 75 years from the date on which the work was first made available. Now, currently, the TTIP is working to extend the life of the author to 70 years. So that's a work in progress. Now we move on to when does copyright expire and what does that mean? So we touched on that before, right? So we said it is life of the author plus 50 years after he has passed on. And when it expires, it enters the public domain, which means that it can be used and reused freely without the owner's consent. Of course, the moral rights will still apply unless it was waived in writing. So this is a definition of public domain when we say that the work has expired and enters the public domain, and it was adapted from the WIPO's Scope and Study on Copyright and Related Rights. The link is there for you to read further. My colleagues can very well post it in chat as well if you want to access it now. And the public domain is generally defined as the intellectual elements that are not protected by copyright or whose protection has lapsed. And this is due to the expiration of the duration of protection. So again, if you have any questions, please post it in the chat. Or if you want to open your mics and ask, please feel free to do so.
Carmen is asking me to say more about moral rights, Anelia.
Right, so moral rights will be addressed in a couple slides later on. So we're almost there, right? So who owns the copyright? So the general rule is that the original owner of the copyright is the person who created the work, right? So that's section 26 of the Copyright Act. So we know this, okay, you create the work, you are the copyright owner, except during the course of employment, okay? And so let's say, for instance, you work in a graphic house, designing house, that is, right? And you're employed. So you create these various graphic designs and you think you own it, but no, you don't, right? Because this is during the course of employment, the employer will be paying you a salary to create these various artistic creative contents. Therefore, the employer would own the copyright in that scenario. And the other exception would be in terms of an independent contractor, right? So say, for instance, you hire a photographer. So you think, okay, I pay this photographer for this particular job. He's taking picture, so therefore I own the copyright in the pictures. But no, he as the independent contractor retains the copyright unless, let's say, for instance, you all did some sort of contract and it was agreed that he would assign the copyright to you for an additional sum of money, all right? So those would be the two exceptions in terms of the general rule. Now, as a copyright owner, you have economic rights and you have moral rights. So under economic rights, these are the commercial rights of the copyright owner. So you have that exclusive right to both authorize or prohibit reproduction of your work, translation of your work into various languages, adaptation of your novel into a screenplay. So you can allow it or you could not allow it, distribution of the work, importation of the work, right? So what we refer to these various acts here is that we refer to them as the card rights. So the right of communication, right of adaptation, right of reproduction, right of distribution. So apart from the economic rights, you also have moral rights. And the moral rights are the rights of the author, the right, you say right of integrity, right of paternity, right? So rights of paternity would be right to be identified as the creator of the work. So you can say, yes, I want to be identified prominently on the work, or you can say, no, I don't want my name to be indicated on the work. Or you can also have that right to object to any derogatory treatment of your work that would tarnish your reputation. So that is your right. So you have your economic rights, and you also have your moral rights to be identified as the author of the work. Now, this picture here is well out of copyright, but the author himself, he still has his moral rights, the right to be identified as the creator of his work. Now, with regard to waiver of moral rights, so this has to be in writing. That right has to be waived, must be specifically identified, and into the circumstances in respect of the waiver must apply. So all of these things has to be identified, the nature, the extent of the modification, and the waiver must be signed by the author, right? So this regard to waiving your moral rights, it has to be in writing, and it's actually very explicitly stated in the Copyright Act. Now, at this juncture, I would pass you over to my colleague who would now venture into neighboring rights and then go into the other areas in terms of infringement and remedies and so forth.
Okay. So essentially, neighboring rights refer to the rights of performers, broadcasters, and producers of sound recordings. Now, there may have been instances where a performer of a song is not necessarily the songwriter or the composer of the song. So I was trying to take a look at our audience to see if anyone here is familiar with the song Cold Water. Can anyone, I can't see the chat, but I'm hoping that my audience knows the song Cold Water that was performed by Justin Bieber and Major Lazer. This is a good example of the marriage of or the interplay of neighboring rights, where the song was co-written by Mr. Ed Sheeran, who did not appear in the performance of the song, but interestingly, Mr. Sheeran would actually own the copyright to the lyrics, while Justin Bieber and Major Lazer would own the performer's rights. So I do hope that you all have an idea of the song. If not, and we have time after this session, I could share it with you, time permitting. The next issue that we need to talk about or address would be exceptions to copyright. This is one of the most topical issues that reared its head during the COVID-19 pandemic, where a lot of persons were asking us as to what is the remit or the exceptions to copyright and what can and cannot be done. Generally, the exceptions to copyright are set out at sections 9 to 17 of the Copyright Act. So section 9, for example, speaks about private reproduction for someone's personal use. However, this is limited to a single copy, provided that it's not in reference to a whole or substantial part of someone's work or a book. So we also have quotations as being an exception to copyright. One of our famous or preferred quotes, given that we're an IP office, is from Albert Einstein: "Creativity is intelligence having fun." Section 11, as I would have mentioned, came up a lot during the past 2 years regarding the reproduction of works for teaching, especially the adaptation of works or uploading of works onto a virtual platform. And what you need to remember with this is that short parts of a work are permissible for teaching purposes once they are for illustration and are compatible with the principles of fair dealing. They must not be for commercial gain. They must be isolated acts. And if it is that they are repeated, they must be on separate and unrelated occasions. I would like to indicate at this juncture that on our website, DTTIP's website, we have a very informative article as to the importance of noting the balance between uploading of works on virtual platforms as well as respect for the authors or copyright owners' rights. Section 12 would be of most interest to you all, given that you all are our librarians. And this is the exception as it relates to reprographic reproduction by libraries and archives. And this is very relevant as persons would have been accessing resources constantly to maybe for their research papers or for any sort of scholarship or study. And a single copy of a work is allowed once it is for these purposes. Section 13 also looks at news reporting as an exception to copyright. And interestingly enough, the reproduction of a single copy of a computer program by the lawful owner is an exception under copyright. So those are just some of the exceptions that I would like to highlight. I do encourage you to peruse the act on your time to see the exact verbatim references to these sections. One of the questions that we were asked in preparation for this seminar was whether or not someone can inherit copyright as part of an estate. I would unfortunately have to give you all the lawyer answer, which is it depends. This will depend on the provisions of a will and whether or not the works that are subject of the will are within the period of protection. So in essence, it would depend on the facts of a scenario. To help illustrate this context, I hope that my audience here knows about our famous 19th century author, Mr. Charles Dickens. He's actually the author of one of my favorite books, Great Expectations. And his will was actually, the provisions of his will were actually contested regarding the interpretation of two clauses. What happened in this case is that Mr. Dickens sought to leave his sister-in-law, Miss Georgina Hogarth, his private papers whatsoever and wheresoever, whereas he sought to leave to his children the remainder of his real and personal estate. It gets interesting because the life of Christ, which is one of his works, formed part of the estate, and a trustee who was dealing with the estate sold the copyright to a publisher and gave a photocopy of the manuscript to be published. So the issues before the court were who was entitled to the money. Was it Miss Hogarth's heirs, or were they Mr. Dickens, the heirs of Mr. Dickens' children, or both? It was eventually held by the court on interpretation that private papers referred strictly to the physical manuscript of the life of Christ, whereas the personal estate passed all the copyright in the work to the beneficiaries. Essentially, the court held that consent must be given from both parties, being Miss Hogarth's heirs as well as the children of Mr. Dickens, in order for the manuscript to be published. Has anyone ever read The Life of Christ? I can't see the chat.
Yes, and I think Shaman
No,
read it.
no, Shaman said no.
No.
I thought she was gonna say yes, she's read it.
I haven't yet either, but I would like to read it one day. So I have actually reproduced the hyperlink below as to where you can access the case study. And if you all are interested, I am more than willing to share a full copy of the case with you all. As we go on, what is copyright infringement? I saw that there were some questions in the chat earlier that was alluding to this area of the presentation. Basically, copyright infringement occurs when it is someone exercises one of the rights that belongs to a copyright owner. In other words, as my colleague would have also indicated, a copyright owner has the exclusive rights to do, authorize, and prohibit certain acts. And if you infringe on any one of those acts, so if you do or exercise one of those acts, you would be committing copyright infringement. Some popular examples include plagiarism, which is copying someone else's work, photocopying books for sale or distribution, or reprinting the whole of a textbook without the permission or consent of the copyright owner. Again, these issues are very topical given the constraints that were presented to the learning environment during the pandemic. What should authors do when they know their work was copied or used without permission? Essentially, you should seek legal advice. We work for the government, so we can't give particular or specific advice to private matters. However, if this is something that is that has happened to you, the IP office can provide you with a list of IP agents who would be able to steer you in the appropriate direction. Remedies for infringement range from seizure, forfeiture, and destruction of infringing copies to injunctions. An injunction is essentially an order whereby a court can prohibit someone from continuing an invasive or infringing action, to 10 years imprisonment, as well as the payment of a fine. Now, what we have done as a team, we have collated most of the frequently asked questions in this area of copyright, and we have basically culminated all of the responses for you based on topics that we would have, or questions we would have encountered in the past. So I would just like to take you all through these shortly. The first question is regarding the use of content from YouTube and Facebook. As we would have emphasized, it is always important to seek permission from the copyright owner. You should also consider why it is you want to use the work. Is it for education? Are you using someone's video to promote something? What is the purpose of the use of the content? You must also look at who owns the content. And you must note that attribution, which is giving recognition to the owner of the work, would not absolve you from any action of copyright infringement. Now, I don't know if you all are familiar with this little box that comes up on YouTube that says this video is not available in your jurisdiction, or this video has been moved for copyright reasons, or anything to that effect. That is known as a takedown provision and is permissible under the Digital Millennium Copyright Act of the United States. Basically, that notice will come up when there is strong suspicion of copyright infringement, whereby someone is using someone else's content, for example, music or songs, without permission. There's also something known as content ID matching by YouTube, which is essentially an algorithm which can attest to whether or not work has been infringed. Another question we have been asked quite often is, if I use information from a copyright-free site, does that mean that I'm infringing anyone's copyright? The answer to this question is, it depends. You need to read those terms and conditions very carefully when you are agreeing to something or agreeing to using a site. Sometimes, and a lot of us are guilty of it, sometimes you may just click I agree to the terms and conditions without actually reading them. What we have done is we have taken the liberty of visiting a hyperlink that has been visited by persons in the past and perusing its contents, its agreements, the terms and conditions, and extracting some key points that you should pay attention to when you seek to use copyright-free sites. So for example, the very first bullet, I'm not going to go into each one, but the first bullet says some music in the YouTube audio library requires you to give attribution or credit to the artist in exchange for using their music in your video. So any term and condition to that effect is something that should raise a red flag to you. Questions on mixes. So quite often we have been asked, hey, I'm a DJ, I'm using works from different persons, I'm making mashup products, what is the likelihood of infringement to me? The answer to that, we would like to again reiterate the importance of Section 8 of the Act and the fact that performers, for example, of works have the right to be identified prominently as the author or performer and subject to any derogatory treatment of their work. Now, what I would like to emphasize at this point is that you should take a look at Mr. David Stopp's book on how to make a living from music if this falls into your area of interest, because Mr. Stops recognizes, as you could see from this excerpt, that not a lot of performers or producers would take kindly to persons using their works without giving credit. So you would see, and I'm quoting him right now at my fourth line here, you would see some authors and performers are quite relaxed, whereas others feel very strongly that their moral rights become violated. So we urge you to exercise extreme caution when you're engaging in these activities. Questions on fair dealing. So someone once asked us whether or not using disclaimer clauses, so to speak, would absolve you from copyright infringement. I would have gone through some of the provisions of sections 9 to 17 of the Copyright Act. Again, I urge you to peruse it in some more detail when you have some time, because as you would see from these sections, you would notice that there are certain qualifications. You can, for example, use short extracts of work for teaching purposes. It must be, if you're reproducing something, for example, it must be a short extract. It must be an act of isolation. It must be done isolation. So please be very careful when you're reading these sections and interpreting them. Questions on ownership, my colleague would have addressed this during the earlier part of the presentation. As she would have indicated, the general rule is that the original owner of copyright is the one who would have created the work. However, where it is created during the course of employment, the copyright owner would be the employer. Questions on releases. So to set the stage or the context for these questions, we have been asked in the past if university students create videos or skits, who owns the copyright? You would need to visit or peruse the copyright policies of those universities or institutions to get guidance on that particular issue. However, you may also need to consider as you go along exploring this area, what sort of clearances you may need. So as I continue, the other question is, would the author of the work that is being performed online have to give permission? Again, we seek to emphasize that getting permission is the best thing to do. It makes sure that you would have gotten some sort of approval from the author or the owner of the copyright, because as we would have indicated, they are the ones with the exclusive rights to communicate something to the public, adapt their own works, reproduce it, and distribute it. Digitization. So this basically summarizes the issue that I was explaining about the uploading of works onto digital platforms. Essentially, those acts require the permission of the copyright holders. So we urge you to visit the article on our website. I will post it on the chat, or one of my colleagues could probably post it for you all to take an in-depth look at this particular issue. Questions on adaptation of works and works recorded during a section. Again, this would follow the same sort of explanation that we would proffer in that article, whereby you need to recognize that the owners or creators of copyright of works own the copyrights, and they are the ones who can do certain things to their works. So you would want to pay particular attention to Section 8 of the Copyright Act. Adaptation and moral rights. I saw that in the chat someone had asked for some more information on moral rights. Moral rights are the rights of paternity, or the rights to be recognized as the owner of a work. It is the right to object to any sort of derogatory treatment of someone's work. And very importantly, as my colleague would have indicated earlier, moral rights can be waived in writing. And any sort of terms and conditions regarding moral rights can be negotiated and agreed upon between parties. So with this presentation, I would like to hand you back over to your chair, and we can address any of your questions. And thank you all for having us.
Okay, thank you. So at this point in time, we would entertain questions. Some of you have started putting your questions in the chat. Kavish, you would seek to respond to some of them if you can, or ask the presenters to respond. Persons who wish to open their mics and ask questions, you can, but first put your hand up and you would be called upon to ask your questions.
Thank you, Nisha. I don't know if anyone had any particular questions at the time. There were some very interesting questions that came up in the chat. So one of the things that we realize is that often authors have many unpublished works. And so there's that question about whether copyright actually protects unpublished works. And the answer is yes. In fact, the duration is sometimes longer in unpublished works. because you're not gaining any monetary benefit from it, usually when it's unpublished. So the questions regarding unpublished works is helpful. I don't know. I don't know. Shaman, did you want to ask a question?
Okay, so I want to go back to the plagiarism question.
Yes.
So when I speak to plagiarism, I speak about it as an ethical issue. I don't treat it as copyright infringement.
Right.
But one of the lawyers or someone in the presentation says it's not criminal, but something that's civil. So if you plagiarize, is it that you can still end up in court?
Well, that was me. That was my responding. I didn't say it wasn't criminal. I said it's most often not criminal in terms of it being a civil offense, right? So it would attract civil remedies. Plagiarism can raise some deeper criminal issues outside of even copyright. In other countries, you could raise issues, and even in Trinidad and Tobago, you could raise issues of fraud. So plagiarism is not to be dealt with very lightly. In the context of plagiarism for, let's say, schoolwork, now you have things like Turnitin that checks for plagiarism, and you have other platforms that check plagiarism. But in terms of plagiarism, generally, it is usually treated in the civil realm. It is usually treated under civil action and things like that. So plagiarism is not just an ethical issue. And yes, I'm not disagreeing that it definitely is an ethical issue, but simultaneously, it is a breach of copyright, as Lorinda would have said in her presentation.
Right. Okay. So I will teach it. I will teach it as such. Coming back to music, or let's say YouTube videos. If you are presenting, and if you're presenting in a class and you put in a YouTube video to explain something, simply crediting the author is not enough. You have to get, do you have to get permission for doing those?
For the purposes, and feel free, Anelia and Lorinda, to add here, but for the purposes of education, it benefits from the exception to copyright, educational usage. So teaching and educational purposes falls under one of the exceptions of copyright.
Yeah.
YouTube is also a paid platform. So when you actually go up and view something on YouTube, you are adding to their revenue.
Okay.
Which is a good thing. The danger lies when you start downloading things from YouTube offline, which I want to be honest, it's very easy to do. There is an attraction to doing it that way. You don't have to depend on the internet connection.
Correct. Correct.
Right? But when you do that, you take away the remuneration from the individual in their views to start, and then you are downloading it without the permission of the creator. So that in of itself can lead to some other tricky issues. So yes, there is an exception for educational and teaching purposes.
Correct. And my last question, I don't want to dominate, but my last question is, when you're talking about music, is there a rule or somewhere I heard that you can use 30 seconds of a clip in your, well, again, for teaching and things like that? Is that still allowed, or is that allowed at all? Where you can just use tiny bits.
So I was about to add, with regard to music and YouTube stuff, quite often, in Trinidad and Tobago at least, one of the exceptions speaks to short parts of published works. The definition of short part has been bandied about and it has been interpreted by courts. And there is no real set definition of what short part is, because a short part of an entire book can mean a few pages well, and a short part of a song can mean a couple of words.
Correct.
If you think about most of the pop music we listen to, it's based around 2 or 3 words or a hook or a phrase that they sing over and over, and that could be deemed a short part. So as Lorinda would have rightfully said, it depends. I know, you know.
I know, the difficulty, yeah.
Yeah, so she would have she would have told you all to read the act. I have no expectation that you're gonna go and read the act. She's very hopeful
No,
that-
I don't think so. I've been teaching on this, but I haven't read the act. But there was a link that she mentioned that I'd like to read, the one about the
yeah,
voting
I think
stuff to
Amelia
the
would have
platform.
put it
Yeah,
up.
I posted the link on the chat.
Excellent. Thank you very much. I'll have a look at it.
Yeah.
Anyway,
And Maria, you raised your hand. Thanks, Shaman, for the questions. Maria, you would have raised your hand. Sorry about that.
Yeah, no problem. Hi, everyone.
Hi.
Yeah, let me start my video. So I have a couple questions. The
course.
first one has to do, the first one has to do with, you know, sometimes people are doing instruction online and there is something, let's say in the background, right? I mean, a photo that may be copyrighted and so forth, or they may have something on and it's like like something that is trademarked in this space, you know, a cup or mug or something like that. What are, in terms of a teaching context, what are the implications for that? And the second one has to do with, you know, sometimes people go to concerts or they go to a game and they pull out their phone and they start to film, right? The event, right? It's really for their personal use, but sometimes it ends up on YouTube or they may end up using it in a teaching context. Sometimes when you're doing production, you are supposed to have a location release form, right? So that, let's say you're doing, you know, you're filming in somebody's house, you certainly don't want to see that end up somewhere and you didn't get the owner's permission. What are the implications for those kind of things with the, you know, people filming personally? And then, I mean, I don't know if that's really a copyright question. And then the other one had to do with, as I say, you had like, let's say trademark stuff or you're in somewhere where really it's, you know, you're supposed to get permission to film, or it's, let's say it's a particular restaurant and it's, you know, trademark symbols or logos. Can you just share a bit on that, please?
Of course, Maria, thanks for the questions. And you went into some deep copyright issues there, you know, like release forms and things like that. So
Sorry.
no, that's great. It's what we're familiar with. So just, if I would answer both questions simultaneously and then we can branch off.
Sure.
First question you would have to ask yourself, and I despise answering a question with a question, but here I go. The first question you'd have to ask yourself is whether it is for commercial usage. What is the intention of what you are doing? So if you are in a public place and you are filming something and it is not for commercial purposes, then you are allowed to do so. It gets more complicated when you come into a private arena. Let's say you are coming, I know that would be our Napa Theatre has a policy on filming and photographs and things like that. Not just of the building itself, because that's an entirely different conversation about copyright and design of the building, etc. But filming things that are happening on the inside. Often they would say no flash photography and no video representations or anything like that. But simultaneously, if there is no statement to that effect, then once you are doing something that is not for commercial purposes and it is for personal purposes only, there is very little difficulty that you can end up in. And because you're not doing it for commercial purposes, you're not earning money from it. So unless you are there to breach some other right of the copyright owner, like their moral rights by not giving them attribution and not referencing their ownership of the work, things like that, or you are there to defame them, then the non-commercial activity isn't in of itself problematic, right? So that was the question about film. In terms of things in your background when you are teaching, IPs everywhere. Just literally IPs everywhere, from clothes that we wear to the toothbrush and toothpaste that I hope everyone used this morning. I mean, if you haven't, well, that's why we have Zoom, you know, just to light it up a little bit. But it's literally everywhere. So getting away from things that represent intellectual property, it's very difficult. You would have a t-shirt on and it may have its trademark on it. You have clothes, you have pens. So you can't really get away from brandishing certain trademarks and brandishing designs and things like that. That is par for the course. If you are looking at it from the, again, commercial perspective and making commercial representations about it, that's where you get into deeper waters, and that's where it becomes tricky. So, I mean, films do it all the time. More TV shows and films, and especially like all these cartoons now, they push brands and they say, oh, come, I want you to sponsor me, come sponsor me, I want your sponsorship. And that's an invitation to the brands to do so. When it's done in books, let me bring it back to this context, there is a difficulty there, because if you are referencing something in a book, that's not just for the purpose of referencing it, but you are using the goodwill of the brand to gain some commercial interest, and that applies generally across the board. That's where you have the problem. So in terms of authorship, and now in terms of you're doing stuff for film, if it is that you're using the brand to increase your commercial activity, then you might end up in a problematic situation. So I go back to the question, you have to ask yourself, what are you doing it for? Is it commercial? Is it non-commercial? If it is for personal purposes, okay. If it's not for personal purposes and you have some commercial intent behind it, which are most books generally in terms of authorship, then you have to be very careful how you reference not just brands, how you reference people, because people have their image rights, how you reference, how you would use someone's picture, image, and if even their silhouettes are protected under certain types of rights. You can get trademarks over your silhouette, and there would be some types of image rights involved, rights of privacy, etc. Especially in the world of celebrities and how that is treated under law and jurisprudence there. So I hope that answered at least part of your question.
Definitely, thank you.
Yeah, so and just to round it off, in terms of releases and releases for places, of course, there are certain places that in order to do any sort of commercial activity, you have to get releases. So Shagaramas is a good example of that. When you go to Shagaramas, if you're going to do commercial filming there, which people do all the time, people do it for weddings and things like that, you have to get permission from the developmental authority to do so. You can't just walk in and start doing it. And there is a small fee to be paid. So there are specific situations that deal with specific things. One of the most important things that David Stopes would have said in his book, I don't know if you're interested in music, and even if you're not reading his book is freely available online, How to Make a Living from Music. He wrote it as a UN publication, David Stopes. So you can look at that book. One of the most interesting things he says about copyright generally is that every single copyright agreement is different from the last and different from the next. There's no sample cookie cutter. Yeah, there are precedents that people use, but the principles of one may not apply to the principles of the other. There are different rights involved. Copyright is by far one of the most complicated areas of law and practice. So I would pretend that this past hour would have gone through everything in any grave detail, but it is a start to answering some of the questions you had. So yes, I took you all down a rabbit hole there with me. Sorry about that. I see a question in the chat, a long question in the chat. Oh no, that was Lorinda's response.
No, yeah, that's Lorinda.
Shanice asked about quotes and Lorinda responded. Lorinda, you want to go ahead and address the question?
I was just explaining while quotation is falls under one of the exceptions to copyright, it would be so to speak qualified in a number of ways. For example, your quotation can't be a substantial portion of the work that you are citing. It must be, for example, a short excerpt or extract of the work. So that's just one of the ways in which it is qualified. And I have again, you will get the presentation. I see a lot of people asking for it, so it will be shared with you.
Might I say there's a lot of information on our website that you could go up and read about copyright. Copyright, as I would have indicated just now, is fairly complex in terms of the rabbit holes. You go down one rabbit hole and you end up in another rabbit hole and another and another and another. It keeps going. And that's IP for you generally. It gets more complex as you go down. But these principles that we have shared here are the general principles that guide the rest of the issues. So once you have a good grasp on things like copyright being automatic, and even in the questions, I know that there was a concern about registration requirements. This is around the world, and I have no problem saying it. There is no registration requirement for copyright around the world. There is an international convention called the Berne Convention that most countries around the world, if not all countries around the world, are party to. And it says that copyright does not require registration. It is automatic. So that is a general principle. And many of what we have said here are general principles. They're automatic. It has to be assigned in writing. The owner is the creator generally, unless it's under a contract of employment, etc. So that should guide a lot. I don't know if anyone else.
I would just like to say one more thing. I think that you all took a very complex topic and did a great job in highlighting some of the principles. It's probably from experience, but first time I'm hearing you all speak to it. And I think you did a really good job of touching many of the principles and putting it across nicely and simply enough to understand. I really must congratulate you all on that.
We appreciate that feedback, Shaman.
Yes,
All right.
Thank you.
In closing, a great thing that any author can do and any business can do is use what is called the Ip Diagnostic Tool. So we were the first in the world to have launched this tool with the World Intellectual Property Organization, the UN arm for IP, in charge around the world. So you can access this on our website, and Anelia, Lorinda could pull up the link and you can access it. It's always there.
I'll share it now.
You don't have to worry. You could literally Google Ip Diagnostic Tool Trinidad and Tobago and it would come up, right? And it's there. It's hosted on both our website and the UN site, and you can actually diagnose the IP in whatever you're doing, whether it's in a business. I know many of you might run businesses, be business owners, and you are authors as well. Many of you are straight up authors. Many of you are doing other things. You can actually look at the diagnostic tool. You can go through, answer the questions, and multiple choice questions, and you can spend just a little bit of time. It's not that long. It'll take you about 15-20 minutes to do something specific on copyright, and you can get a lot of answers to questions you might have, very specific answers to deal with things that you may not necessarily be aware of, or things that you don't even know how to start asking. And it's very helpful. So you could have a look at that.
And also we would appreciate the feedback on this tool as well, so that we could also try to improve.
Yes. So I don't know if there were any other questions by anyone else. I don't think so. Over to you, Nichelle.
All right, so if there are no other questions, we now bring this presentation to a close. So I just want to say thanks to Tobago Writers Guild and Mrs. Joel Green George, Marketing Director of the Tobago Writers Guild, whose idea it was for us to partner to celebrate international observances. It was out of this agreement to partner that the idea of having this presentation was born. So I say thanks to the Tobago Writers Guild. A special thanks is extended also to Ms. Gabrielle Finance, who was part of the planning team so that this session could have taken place. A special and hearty thanks to the Intellectual Property Office and the presenters for the informative presentation, as well as your patience and clarity in addressing all of the questions this afternoon. Thank you, Mr. Sitahal. This was the liaison person. You warmly accepted the invitation to present, so we thank you for that. We thank you for all the questions that you have answered and would have done so excellently. It was indeed a pleasure working with the Intellectual Property Office once more, and we look forward to more partnerships in the future. Thanks to all the participants. We thank you for your attendance, your questions, and for your general support. We hope that you are better informed about the whole matter of copyright, and that those of you who are creators, that you will continue to create work with more confidence. And those who use information, we hope that you do so responsibly. We would be sharing the presentation with you, so look for it in your email. You should receive it within the next 2 days or so. Again, I say thanks to all of you once again. Do enjoy the rest of the evening.